All right, welcome everybody to the fall edition of the McGuire-Woods Antitrust and Competition Law Update. My name is Brent Justice. I'm a partner in the Richmond and Washington, D.C. offices of McGuire-Woods. I'll go ahead and introduce the people that are going to be speaking today. In addition to me, we have Holden Brooks, who is a partner in both our Chicago and our Washington, D.C.'s D.C. offices. Nick Giles, who is a partner in our Richmond office. Reed Smith, who is our partner in the Washington, D.C. office. And last but certainly not least, our newest addition to the team, Meg Lewis. Meg Lewis was until a little over a month ago, if it's even been a month, an assistant chief at the Washington Criminal Section of DOJ, but now she is a partner in our DC office, and so we will be especially interested in hearing what she has to say in her section of the update today. I want to lead it off today, start talking about Robinson-Patman Act updates, and we're starting with Robinson-Patman so people don't fall asleep at the end when we're talking about Robinson-Patman, which isn't always number one on everyone's compliance agenda, but we do have some important developments. Then Meg will talk about criminal antitrust updates. Nick is going to talk about sort of the joint statement on competition and AI. And then finally, Reed and Holden together are going to cover sort of hugely important updates to the sort of final HSR rules that came out just a little over a week ago. So to start with, Robinson-Patman Act. Maybe the first update for everyone is, yes, the Robinson-Patman Act still exists. It's still there, still in the books. But we have, it's showing some signs of life that we thought it was helpful to sort of go over with people on this call. First, to give you some basics on the Robinson-Patman Act. The Robinson-Patman Act prohibits a seller from discriminating in price or engaging in certain other unequal treatment when selling to competing resellers of a commodity product. Said more simply, basically prohibits a company from selling the same good to two competing prices. The same good to two competing purchasers at significantly different prices around the same time. Now, this law on its face doesn't really seem to have a whole lot in common with sort of preserving competition. In fact, it in many contexts would make discounting illegal. So why do we have it? Why is it an antitrust law? Well, it was passed back in the 30s and the 20s, back when A&P, the now bankrupt grocery chain that was running mom and pop grocery stores out of business. Historically, it's not been an enforcement priority. In fact, for many years, economists would have described the Robinson-Patman Act as sort of, quote, economically illiterate. And for that reason, most administrations have really been loath to bring any enforcement activity. There were no Robinson-Patman Act cases under George W. Bush, Obama, or Trump. There was one Robinson-Patman Act case under Clinton and 5 under Reagan. So if you're trying to make a living defending government Robinson-Patman Act cases, you were doing pretty bad. Also, the Robinson-Patman Act has generally not been a priority for people because it really doesn't lend itself to class action treatment. I actually personally litigated the last attempt by plaintiffs to bring a Robinson-Patman Act class action, and that case involved the sale of music CDs. And we represent the Circuit City. If that gives you any sense of how long that's been. Finally, the Robinson-Patman Act is also subject to a lot of defenses, such as meeting competition, cost justification, functional availability. And frankly, meeting competition avoids a lot of price discrimination situations because people often only give a lower price if they have to do it to meet a competitor's price. So again, in light of the low enforcement priorities, in light of the fact that it's not susceptible to class action, and frankly, in light of the fact that in most cases, if you're discriminating against a customer, you can sort of make it okay with that customer by giving them the discount they're asking for. Historically, counsel attorneys have not advised clients to be super concerned about Robinson-Patman compliance. So what has happened? Since 2022, When Commissioner Bedoya joined the FTC, he's really sort of made its personal crusade to reinvigorate Robinson-Patman Act enforcement. If you've gone to the spring meeting, you've heard him tell stories about the mom and pop grocery stores on Indian reservations that can't stay in business because the Walmart 2 hours away is so much cheaper that people will drive 2 hours to go buy all their groceries from Walmart instead of from the mom and pop grocery store, and how this is really unfair, not just to the mom and pop grocery store, but to the people on the reservation. Similarly, you had just this March, you had Congresswoman Scanlon and Senator Warren, wrote a letter to the FTC, urging increased enforcement of the Robinson-Patman Act. One of the hooks for that letter is the observation that consolidation in the food industry has made the issue even greater. You have 4 retailers that account for 1/3 of all grocery sales. The whole rationale between the Kroger and Albertsons transaction is to increase leverage and decrease purchasing costs. So there's a lot of pressure. There's a lot of pressure out there by these big retailers to extract discriminatory pricing from manufacturers and sellers, not just in terms of lower prices, but also in terms of large retailer demanding things like high slotting allowance fees and high volume discounts, that small grocery stores can't offer. And it does seem that the FTC has followed through on this. There are significant investigations into wine and liquor distribution, as well as soda manufacturing. We know of live CIDs in both of those industries. I personally know, the lawyer at FTC that's heading up Robinson-Patman Act enforcement, and that's pretty much all she's doing these days. So it's a real thing. It's going to become a bigger part of our lives sooner than we want. Finally, for those of you in the pharmacy space, in the pharmaceutical space, the Robinson-Patman Act has been touted as a way to maybe go after pharmacy benefit managers who are supposedly, paying and accepting rebates in exchange for excluding other lower cost drugs. So it's not just an uptick in federal enforcement, though. We've seen an uptick in civil litigation as well. I know there was a case just filed in New Mexico a few weeks ago. It's a little premature to talk about that one, but we do have 2, significant private plaintiff cases in the last couple of years that are significant because, the first one, this LA International Corporation versus Prestige Brands Holdings, a bunch of wholesalers, one of the first jury verdict, the first plaintiff side Robinson-Patman Act jury verdict since 2002. Now, it was only $680,000, so it's not that exciting. But they did get a permanent injunction against the manufacturer who had been accused of providing Costco and Sam's Clubs with payments for advertising promotional services that weren't offered to the plaintiffs. The Costco and Sam's Club argued that, we're not really in competition with these plaintiffs. They're wholesalers. We sell predominantly to the public, but, that didn't carry the day. And one of the reasons that didn't carry the day was, the discount at issue in this case was like 17.5% to 38% lower prices that Costco and Sam's Club were paying over these wholesalers. Just last week, October 6th, here in this Innovation Ventures case, it's another case I wanted to raise. The Supreme Court rejected an appeal from the manufacturer 5 Hour Energy, who had challenged the Ninth Circuit's holding that Costco and plaintiffs' wholesalers were competitors for purposes of whether the Robinson-Patman Act applied. Basically, in that case, just like the Prestige case, the wholesalers were getting a much worse price than Costco and Sam's Club, and the wholesaler sued, and the Ninth Circuit reversed the district court, and the Ninth Circuit held, listen, Costco sells to small grocery stores and convenience stores just like wholesalers do. So those are competing sales, and they're susceptible to enforcement of the Robinson-Patman Act. So what do we do? What does this mean in terms of sort of practical steps for you guys? First, start thinking about implementing policies, to contemporaneously document, the rationale underlying any substantial discounts. And I say substantial discounts because obviously, the bigger the price discrepancy, the higher the risk that you're going to run into litigation or some sort of investigation. Secondly, consider providing Robinson-Patman Act training for those employees who are involved in pricing and discounting. Third, assess what existing promotional and discounting programs you have to determine whether those programs are functionally available to all customers. And finally, going forward, talk to your business people about designing, your future promotional and discounting programs to reward purchasing practices rather than purely volume discounts. And I'll dwell on that last bit for just a minute, because I think sometimes people are just flabbergasted to hear that volume is not a justification. It's not a defense under the Robinson-Patman Act, unless the volume is so great that it results in a cost savings, and then the discount can only be the amount of that cost savings. You can't just give Kroger a better price because they buy more. So it can be a challenge to design promotional programs that are functionally available. And I know that, we've worked with manufacturers, and sometimes one strategy is to, give your discounts based on, share of shelf space rather than total volume, because, you have to come up with ways to develop promotional programs that are functionally available to small retailers as well as large retailers. Now two takeaways. Again, first of all, with Robinson-Patman, it only applies to commodities, right? It doesn't apply to services. Secondly, in terms of real world exposure, your highest risk is going to be in situations in which, your customer is taking what you sell them and turning around and selling it for the exact same, basically unchanged. If you're selling an input, that's a small part of the price of the final sales price. The likelihood that your customer is going to discover they got discriminated against, and the likelihood that that discriminatory price is going to, move the needle for them is much lower. And so the risk is much higher, in those industries in which you're selling goods and people are taking and just turning around and reselling it, sort of the traditional wholesale retail model. So that is enough Robinson-Patman Act for anybody on a Wednesday. I'll pass it along to Meg, who'll talk about our criminal antitrust updates.
Thanks, Brent. So talking about criminal antitrust updates, I wanted to provide first a quick hit on the upcoming criminal cases that we're going to be tracking, particularly some of the cases that are going to trial next year with the Antitrust Division. So the first of these cases is the United States versus Brubaker case, which is the case where the United States has appealed the Fourth Circuit's decision that vacated a Sherman Act conviction for bid rigging because the relationship between the parties had both the horizontal and vertical elements. So it is extremely rare for the United States to be the party that's seeking cert in a criminal antitrust case. If the Supreme Court takes it, it's going to be the first criminal antitrust case in decades that has gone up. And the outcome, whether or not the Supreme Court takes cert, is certainly going to affect how criminal antitrust cases are charged at a minimum in the Fourth Circuit. So that's one that we'll be watching closely. The defendant in that case did file a cross petition in which he is asking the Supreme Court to find the entirety of the Sherman Act unconstitutional. So that will also be interesting to see if the Supreme Court is interested in biting on that lead. The next case we're tracking is the U.S. v. Martinez et al. Case. This is the one that folks may have heard of referred to as the Transmigrante case. This is the case that involves violent crimes and some of the alleged ties to the actual Mexican cartels. Now, I'm imagining that's not a fact pattern that is really all that relatable to folks in this audience, but I think what is notable is that one of the charges is a Section 2 conspiracy to monopolize. And so that is currently it's set for trial to go to trial in February of next year, and I think it will be interesting to see how the jury instructions play out in a litigated context in a Section 2 case. Next one is Lopez. That is the DOJ's only currently charged labor market case, which is alleging wage fixing and some wire fraud counts. That one is going to go to trial in March, and so we will see if the Antitrust Division will get a jury verdict on a wage fixing charge. Next one up is the Ceres security case. This one is also set for trial in March, although, given the international aspects of it, remains to be seen if that date will stick. But This one is notable only because it is, involving international companies and Belgian nationals. And so the Antitrust Division is continuing to be active in the international space. Next one is the US v. Tomlinson and Byrd. Byrd is the remaining defendant in that case. This one is the much publicized case in which the Antitrust Division got a Title III wiretap involving bid rigging for some public procurements out in Idaho. That one is set for trial in April, so I imagine that will be interesting to see the evidence that comes out there. The last one on this list is the US v. Bisco case. This one is a sort of heartland case for the Antitrust Division. It is a procurement collusion case, and it's charging price fixing and bid rigging on over $100 million of government contracts, primarily in sod. So these are erosion control services that the state of Oklahoma was procuring, and the charges are price fixing and bid rigging. Several of the defendants have pled guilty, but the remaining defendants are set to go to trial in May. So that, I think, list sort of encapsulates right there a list of the priorities of the criminal program. But I wanted to turn to a little bit more in-depth look now at one of the hot topics in criminal antitrust enforcement these days, which is this notion of algorithmic price fixing, and sort of where along the spectrum does conduct fall when it's either information sharing versus price fixing. And I think that that's somewhere that a lot of companies are concerned about, because I think the lines are perhaps shifting or not entirely clear of how the DOJ is sort of approaching these types of cases. So we're going to start with looking at the AgriStats case. So this one is the civil case involving an information exchange conspiracy, is how the United States charged it. And AgriStats was collecting the detailed information from its subscribers. It was distributing anonymized data, but the subscribers knew who the participating companies were. So DOJ obviously has brought that as a civil case seeking an injunction. It survived a motion to dismiss. But I think what is even more interesting is that earlier this month, DOJ filed a statement of interest in the private litigation that's going on related to the AgriStats information exchange. So in this one, they took the position that these standalone information exchanges, meaning that where they are not alleged as part of a tacit price fixing conspiracy, but a truly standalone information exchange, can also violate Section 1. And even if the data is anonymized and aggregated, that still doesn't get you into the clear. So I think that's a notable position that they're taking, as well as emphasizing this notion that proof of a purpose to restrain trade or competition is not required if there's proof of anti-competitive effects, coming from the US Gypsum case. So I think the concerns, again, for people that are entering into these types of information sharing agreements, whether it's done sort of manually through benchmarking or through algorithmic exchange, that they're identifying the anti-competitive concerns based on the sensitivity of the data, granularity, public availability, and the contemporaneousness of this data when it's being disclosed. So we see it's an aggressive position, but they're still not taking the position that information sharing alone is per se price fixing. So then we look next at the sort of group of these private hotel cases. These are private actions, or I should say were private actions, alleging algorithmic price fixing in the hotel industry. And so the first one, the Gibson case, was dismissed in May. The court considered the allegations to be one of a traditional hub and spoke conspiracy, but found that they were lacking any allegations that there was the rim, meaning there were no plausible allegations of a conspiracy between the horizontal competitors. So the court listed a couple other factors there: no exchange of confidential pricing, the hotels were not bound to follow the recommendations that the algorithm spit out, in concluding that the plaintiffs had not alleged a plausible case, and dismissed it. In the second one, the Caesars Entertainment case, DOJ in this one filed a statement of interest and sought to rebut some of these conclusions from the judge in the Gibson case. They asserted that direct communications between competitors are not required to establish that rim in a hub and spoke conspiracy, and that retaining some authority to deviate from the algorithmic pricing recommendations is not fatal to a per se claim. The idea being that you can both have a tacit agreement among the competitors, and even if you're reaching a tacit agreement on a starting point for a price, or a list price, or a base price, and you deviate from that, it is still unlawful to fix or agree upon where that pricing starts in that instance. So the other thing that they were suggesting is that you can violate Section 1 by delegating your pricing authority to a common entity. So I think that that is sort of, again, pushing the bounds on what concerted action really means in this context. So the court was unpersuaded, it appears, and they entered the motion to dismiss late last month. But interestingly, they emphasized that one of the factors in the dismissal was that the pricing recommendations were not based on a pool of confidential competitor data that the algorithm was drawing from. So that then brings us next to the landlord cases. That's the Yardi Systems case and, of course, the RealPage cases. So the Yardi case, the statement of interest that DOJ filed was largely repeating the arguments that they made in the hotel case. That one, the oral argument is set on a motion to dismiss, so we'll see what the outcome of that is. The RealPage litigation, I think, is the one that probably most folks are most familiar with. This is the one where the private litigation survived a motion to dismiss, and that private litigation is progressing through discovery. DOJ filed its statement of interest in that private litigation in November of last year, and it was arguing that a per se violation occurs when competitors knowingly combine their sensitive, non-public pricing and supply information in an algorithm that they rely upon in making pricing decisions with a knowledge and expectation that other competitors will do the same. And in that statement of interest, what they say is under the statute, meaning the Sherman Act, it is per se unlawful for competitors to join together their independent decision-making power to raise, depress, fix, peg, or stabilize prices. So again, they're relying heavily on this idea of a tacit agreement or a joining together of these independent economic decision makers. And they are suggesting that that in and of itself amounts to price fixing, which is per se unlawful. So interestingly then, we fast forward to earlier this year when DOJ filed its own case against RealPage. It filed a civil complaint that on its face is pleading an information exchange that is unlawful under a rule of reason type analysis, not a per se analysis. However, the interesting part of it is that the complaint does use that very similar language where it says that the landlords are therefore joining together in a way that deprives the market of fully independent centers of decision-making on pricing. So that's almost exactly mirroring the language that they previously used in their statement of interest to suggest that it is in fact per se unlawful. So I think it's going to be very interesting to continue to watch the RealPage litigation unfold and see whether DOJ more broadly, even in this case, is continuing to pursue these types of information exchanges as per se unlawful, or whether they will be continuing to rely on sort of the rule of reason analysis. So lastly, I wanted to bring it back to some of the sort of the basic principles on two cases where DOJ did actually prosecute price fixing involving some sort of algorithmic or information exchange. So the first one is an older one. This is one where online marketplace sellers ended up pleading guilty to implementing a price fixing agreement through an algorithm. And the second one involved the low-tech version of an algorithm or a low-tech version of an information exchange. And this is one where it sort of echoed the now infamous speech that the FTC put out several years ago saying, if a guy named Bob can't do it, then an algorithm can't do it. And so this is essentially the low-tech version of the guy named Bob, where, among other things, these competitor companies were using a concrete salesman as this conduit to share pricing information for the purpose of coordinating price increases. Now, of course, in both of these cases, there was a lot more additional evidence that was suggesting and supporting and proving an agreement between the competitors, which is, of course, what sort of brought it into more of the heartland of the price fixing cases that DOJ does prosecute criminally. So I think it's sort of showing that DOJ has not abandoned their core principles of continuing to prosecute only price fixing criminally and not mere information sharing, but it is certainly an area that is developing and one that we're going to keep watching. So takeaways, I think, DOJ is taking this aggressive stance, whether it's algorithms, joint activity, combinations joining together, and they're continuing to aggressively enforce procurement fraud and procurement collusion through their procurement collusion strike force, most notably. They are continuing to prosecute labor market cases, wage fixing, no poach agreements. That has not gone away, notwithstanding some of the dismissals and losses at trial from years past. And they are also continuing to pursue Section 2 cases criminally, and I expect we're going to continue to see more of those. And that's it from me on the criminal side.
All right, thanks very much, Meg. I think everyone will agree what a great addition Meg is to our antitrust team here at McGuire Woods. We're thrilled to have her on board, and thrilled to have her be able to showcase some of her insight in this setting. So I'm going to talk about something that happened over the summer, which was the issuance of a joint statement on competition and antitrust issues as applied to AI. So back in June of this year, 4 competition authorities in a cross-jurisdictional statement issued what they called a joint statement on competition in generative AI foundation models and AI products. And it was signed by Lena Khan, the chair of the FTC, Jonathan Cantor, the Assistant Attorney General for the Antitrust Division at the Department of Justice, Sarah Cardell, who's the CEO of the UK CMA, or the Competition Markets Authority, and Marguerite Vestager, who's the Executive Vice President and Competition Commissioner of the European Commission. So a cross-jurisdictional effort here. And this is not particularly notable. These competition authorities across the world, often collaborate with one another and have issued joint statements in the past, certainly. It is interesting. These are 4 jurisdictions with obviously very different laws, different approaches, and different priorities. And sort of it is interesting to see how they all come together and find common ground on emerging issues such as this. So let's see what they had to say. So the main thing that they recognize, which makes sense, is that we're at this what they call technological inflection point. AI has sort of burst onto the scene in the last 2 to 3 years, and has very quickly become part of everyday life, both for businesses and consumers. And what these authorities recognize is that look, AI can be a huge opportunity. There's so much potential for good there, and particularly potential for good that could advance the aims of competition regulators. What they said, catalyzing opportunity, innovation, and growth. But of course, they also recognize that there are risks. And they really focused on 2 sort of strands of that risk in this, what ends up being a very short statement. The first is the risk of decreased competition or restrained competition in the markets for AI services themselves, focusing on 3 sort of areas: a restriction on the availability of key inputs that are necessary for the development of AI technologies, attempts by firms with existing market power in digital markets to extend their dominance into AI. Right? Do the Facebooks and the Googles and the Amazons of the world have a leg up when it comes to AI? Consolidation in those AI markets through joint ventures and partnerships. And then the second strand of risk they spoke about with AI is in the use of AI in other markets. And we've seen a little bit of that in action already based on Meg's observations about algorithmic price fixing cases. So algorithmic price fixing is really sort of the forefront of this second strand of risk, which is, can AI be used in a way in other markets that threatens competition or undermines the aims of the antitrust laws. So highlights here, and these are really in that first strand of risk. concern that a small number of companies could control data and expertise at the expense of what they call disruptive innovation. So you do see in this statement, which is typical certainly of the U.S. regulators, this reverence for and concern with protecting what they call disruptive innovation. So they look at the fact that already in AI's kind of nascent times, there are a small number of companies that are dominating it. The concern that they have is that large incumbent digital firms are positioned to ward off threats from disruptive innovation, and that those entrenched firms are already making their mark and entrenching their power through widespread partnerships and connections in this space. So you do see a very real focus on, look, we're at the beginning of this market. We're at a technological inflection point, as they noted. What can we do to lay the groundwork for this to be a well-functioning and competitive market? And already pointing to certain features of that market and certain characteristics of that market and certain players in that market that are already threatening that robust competition that they're looking to secure. So the statement lays out three principles that these four regulators believe should motivate their enforcement efforts when it comes to competition in AI. The first is fair dealing, and there's an express warning against the use of exclusionary tactics. This is nothing particularly new or noteworthy. I think all competition regulators across the world would say that they, want to foster fair dealing among market participants. The second principle they focus on is something called interoperability. And this is noteworthy given the fact that there are multiple regulators, multiple competition authorities who have signed on to this statement. So certainly in the EU, there are much more robust guarantees of interoperability for nascent firms in the tech space who maybe participate in adjacent markets, who want to make their product or their service interoperable with that of an entrenched dominant market player in a digital market. So if we think about this in terms of something like a market for data, for big data, and an adjacent market for data analytics services, right? The efforts by an entrenched player in the data space to make their product inoperable with the products in adjacent markets of nascent competitors is heavily scrutinized in the EU. And so by signing on to this agreement and putting this focus on interoperability, the FTC and DOJ have really thrown their hat in that same ring and have said that interoperability is something we care about as well. And this makes sense when we think of AI. AI products and AI uses are exceptionally dynamic. And if they really want to, foster that innovation that they're focusing on, they really do have to focus on rules of interoperability as applied to major existing players who control the data and the expertise in those AI markets. So the quote here that I pulled out, which I think is very telling, any claims that interoperability requires sacrifices to privacy and security will be closely scrutinized. So there are a line of cases, not necessarily in the AI space, but in the tech space more generally, that focus on efforts by small tech startups to sort of advance their products on the platforms of major tech companies, the Facebooks, the Googles, and the Amazons of the world. And often what you see as a defense to exclusionary tactics there is we can't let just anybody on our platform. We can't render our platform, interoperable to anyone who walks off the street and wants to do so, because that requires sacrifices to privacy and security. And so you see the DOJ and the FTC, as well as the two European regulators, drawing a line in the sand here and saying, this is going to be a defense, a rationale that we're going to scrutinize carefully. We're really going to look at carefully. And certainly privacy and security are big issues, but they're not just going to be a get out of jail free card once you invoke them. The final principle that's highlighted in the statement is one of choice. The regulators commit to scrutinizing mechanisms of lock-in that could prevent companies or individuals from being able to meaningfully seek or choose other options. And finally, the statement goes on to highlight a handful of other considerations. Algorithms that facilitate collusion. Meg spoke about that, and some sort of already inchoate efforts to advance those priorities by the Department of Justice. Algorithms that advance price discrimination, which is slightly different, but again harkens back to what Brent talked about at the outset about the Robinson-Patman Act's resurgence. I think regulators are going to look closely at whether there are pricing algorithms or AI-driven pricing models of any kind, dynamic pricing, value-based pricing, those sorts of mechanisms that might be advancing price discrimination. Maybe not in the same, in a way that would technically violate the Robinson-Patman Act, but in a way that would nonetheless harm competition. And certainly, I think FTC, who has a little bit of a broader regulatory mandate in Section 5 of the FTC Act than does DOJ, would view that as within its purview. And finally, and apropos of the FTC's purview, the statement highlights consumer protection risks in AI as well. And so, they make clear this is not just a competition issue. Certainly it is a competition issue, but it's not just a competition issue. There's a big consumer protection risk with AI as well. And two particular examples they call out: firms that deceptively or unfairly use consumer data to train their models in a way that can undermine privacy, security, and autonomy. Unclear sort of exactly what autonomy means in that context, but certainly, something to keep an eye on. And then sort of informing participants in AI markets that they must inform consumers about when and how an AI application is employed in the products and services that they purchase and use. So that we can expect certainly to be high on the FTC's priority agenda, given its consumer protection mandate, as well as state AGs. So some takeaways from this statement, some things to think about: enforceability, right? How this policy statement translates into action. It's a policy statement. It's not a law. And as I said before, these authorities, these regulators do have different statutes that they're dealing with. The competition laws and that the EC has at their fingers are very different than what the Department of Justice and the FTC have. So it will be interesting to see, how, with concepts like interoperability and others, how these regulators use their different tools in their toolboxes to go after competitive threats in AI markets. And then, where we see this might play out: civil cases, criminal investigations, and, is there going to be an increased scrutiny of AI implications in merger enforcement? Certainly, I think that we can expect that and have already started to see that when it comes to market participants in AI markets. But I think one thing to keep an eye on is, are AI products and certainly access to big data for AI going to become an issue in unrelated mergers as well. And then I put here, fool me once, right? I think there's this sense that these regulators are trying to avoid the mistakes of the past when it comes to digital markets. So if we're at a technological inflection point with respect to AI, I think we're at a legal inflection point with respect to more traditional digital markets. You've got ongoing enforcement actions against Google, against Meta, against Amazon, obviously very large entrenched players in the tech space. And I think what you see in this statement is a little bit of an effort to say, okay, we're gonna get on this early, and we're gonna apply the lessons here, to these markets at the outset. A little bit of policy into action. We've seen the algorithmic cases. There's a well-publicized investigation into NVIDIA, who's the maker of the world's leading supplier of the chips that are needed to support AI efforts. FTC has scrutinized what are sort of joint ventures or strategic investments between new AI companies and established digital market players. So Microsoft's investment in OpenAI, for instance, and Google and Amazon's investment in Anthropic, which is another sort of nascent AI company. And in the Google case, in the Eastern District of Virginia, which has been very well publicized over the last month or so, it's now at the remedies stage, having been declared a monopoly, and in filings to date, DOJ has signaled that that Google's use of AI and how it can use AI going forward are questions that are factoring into what they think about remedies in that case. So the key things to understand here, the key questions to sort of ask yourself and ask your business, right? Are you providing any AI services, right? Are you an AI company? Chances are probably not. It's a small kind of emergent space, but certainly if you are, there are considerations to think about there. Are you consuming any AI services? And here the answer is, maybe more likely to be yes. What vendors are your business clients relying on? And, what have you done to sort of, put risk guards in place for those vendors? And are you contributing to any AI services? So what are your business clients doing with your company's data, right? Are there vendors that are sort of pay to play when it comes to data? You give us your data and then you can have access to this product because as we've seen over the last year and a half or so, there could be competition related implications to that sort of behavior. So questions to think about in this space. And thank you everyone for joining and for listening in.
All right, next we are going to discuss this new HSR rule that came out on October 10th, and Holden and I are going to tag team this one to double our efforts in understanding this rule. So October 10th was when the rule came out. The FTC issued the final rule with DOJ's concurrence, and folks might remember a while back, in fact, June 2023. The FTC issued a proposed rule. So it took them over a year to go from a proposed rule to a final rule. In that amount of time, they had a comment period for public comments, also presumably had some internal discussions about how the rule might change, and we'll talk about how some of the proposed rule got left out of the final rule. But despite some of the proposed rule being left out, this final rule still greatly increases the amount of information that needs to be provided with HSR filings and expands the topic areas of that information. The FTC has said that these changes are necessary because there are significant information gaps and asymmetries that have grown over time between the information that merging parties have internally and the information that the FTC has about those parties. And the FTC has said that these information gaps undermine their ability to conduct a review of mergers and acquisitions. One impact of these rules is that the FTC, as they're receiving more information up front in the HSR filing, they have said that they will have less of a need to go out to customers and competitors of the merging parties in their initial review to gain information about the markets and the companies that are involved. So I mentioned before that there's some differences between the proposed rule and the final rule. The final rule adopted many, but not all of the changes that were proposed. A couple of the examples of things that were left out were labor information about the merging parties, geolocation data about their businesses in certain instances. The final rule narrowed the group of officers and directors that has to be reported through the filing. And fewer drafts of documents need to be submitted under the final rule than as what was proposed. And there's probably some influence here of the two recently appointed Republican commissioners, Andrew Ferguson and Melissa Holyoke. They were appointed between the time that the proposed rule was issued and the final rule was issued, and each of them published separate statements. They both voted in favor of issuing the final rule, but their separate statements describe and hail, and in some instances, the fact that some of these areas were left out of the final rule. And then finally, it's unclear whether there are going to be litigation challenges to the rule. Many folks probably know the background of the FTC's non-compete rule, which has been successfully challenged in court and is now being appealed by the FTC. I think it's probably less likely that this rule gets challenged, but very possible that there are challengers who will file litigation here in the coming weeks. So Holden's going to take the next.
I'll just say that we have an extremely short amount of time to go into what I will characterize as one of the biggest developments in antitrust law, certainly on the M&A side since I've been practicing. And we would just encourage you to, shoot us an email, set up a time to talk if there's anything that you would like to discuss in greater detail. We're going to hit the highlights today. So the first thing that I'm going to cover is when the rule goes into effect. Well, it goes into effect 90 days from when it is published in the Federal Register, which is kind of anyone's guess. It could be tomorrow, it could be, next week. But the current feeling is that you should count on this new rule being in place and in effect by the end of January of 2025. Now, there has been some discussion about whether there will be a litigation challenge to the rule. I think there are two things to note there. One of them is that the FTC is characterizing this as simply a change to the HSR form, right? As a ministerial change. They acknowledge that it will have some, major impact on how people approach this process, but it's not the same as, for instance, the FTC's proposed rule on non-competes, which would have, a huge widespread impact. So even if somebody brings a litigation challenge to this rule, it's not clear that a court would necessarily issue an injunction to stop it from taking effect. So we do think it's prudent for people to expect that the rule will be in effect and affecting any filings that they make as of the end of January 2025. But keep your eye on when that publication in the Federal Register takes place. But any HSR filings that you make before then will be under the old rule that you may be used to if you have been through that process before. One thing I also wanted to note here is that even if your initial filing is subject to the current rules, if you're in a situation where at the end of the 30-day initial waiting period, you're asked to pull and refile, and that pull and refile is taking place under the new rules, you may actually be faced with having to do a pull and refile under those new, more burdensome rules. I think that's still up for debate, but something to keep in mind. And it's worthwhile to keep in mind because those new rules are significantly more burdensome. The FTC itself has estimated that the average time to complete an HSR filing will be about 3 times as long as it was previously, with an average of about 68 additional hours on top of the time that it has taken us all to do this for many years. And I think that depending on the party, the type of parties that are involved, whether it's private equity, where there may be a lot of information to gather about structure and so forth, it really is going to depend. It's going to be very fact specific with respect to the types of entities, the type of deals, the scope of the overlap, et cetera, to figure out how long this is going to take. But we're going to address some specific guidance about that at the end, so I'll hand it back to Reed.
Okay. What new information might be required? Well, as Holden mentioned, we are really just skimming the surface today, just have a few minutes. And so a full description of the new information that's required is beyond what we're going to go in, but we're going to hit a couple highlights. Some of the highlights are additional narrative descriptions and identifications of overlaps, as well as the rationale behind the transaction. There are additional categories of business documents that will need to be submitted, and a requirement that those business documents be tied in some way to the stated rationale that's being described. There's significant additional information about the structure and the ownership of the parties, about the ownership structure involved in each of the acquired and acquiring entities. There's disclosure of officers and directors in some instances that could be quite a burdensome effort to be able to identify when those need to be produced. And then there's some additional information, particularly by the acquired person regarding prior acquisitions. So just touching really briefly, narrative descriptions. As many of you probably know, the current rules only require a really short factual description of the transaction. The final rule will require narrative descriptions in a number of areas, overlaps. There'll have to be a description of categories of customers who have to purchase the overlapping products, supplier-customer relationships. And again, if you want to talk more in depth about these changes, feel free to contact us after this webinar, and we'd be happy to go into more detail.
I think that the category of documents that are going to be required to be included under the new rules that are really going to surprise people in terms of the burdensome nature of the collection process is what we used to call 4C documents that are now called competition documents. These were, under the old rules, documents created by or for an officer or director of the ultimate parent entity or any controlled entity that related to the transaction and very specific topics like competition, competitors, competitive landscape, market shares, et cetera. And for a long time, the way to sort of cabin that search was to, again, as I said, these were documents that were only created by or for officers or directors. You really only needed to think about that group of people and what was in their files. The new rule now expands that to include the files of someone they're calling the supervisory deal team lead. That person is someone who is primarily responsible for supervising the strategic assessment of the transaction. So now you not only need to worry about what is in the files of your officers and directors, but also, need to consider who is the supervisory deal team lead. What do they have in their files? I'll be honest, usually the person who is primarily responsible for the strategic assessment of a deal has a lot of candid communications and analysis, et cetera, in their files. So I think that, in making this change, the FTC has realized that they have, expanded the aperture of what they have access to and what they're looking at in a significant way. In addition, the parties are going to have to submit what are called plans and reports. And these are documents that relate to, these competitive topics, competition, market share, et cetera, in an overlap area, if the parties have an overlap, if they're in the same, if they're offering the same goods and services in the same geography, et cetera, that were distributed to the CEO of the, call it ultimate parent entity or any entity within that, entity. So the target or the acquiring company that may be involved in the overlap, or any members of the board of directors. And that would be for 1 year prior to the filing. So a lot of that is normal course business documents relating to the businesses involved in the transaction that people are not used to having to produce with an HSR, which typically those documents were limited to documents that had something to do with the deal, not just the business. So that's another way that the FTC is significantly expanding the scope of what they have access to in an HSR filing. I think that the other thing that may surprise people, another way that the FTC is expanding its view here of what's going on is they want you to give them detailed information of your officers, of the party's officers and directors, and what other companies those individuals serve as an officer or director. And the goal here is to be able to spot what we call Section 8 interlocks. So it's where officers and directors of one company in a space have access to and influence over other competitors. They want to map this out. It has been a real focus of the enforcers for the past couple of years. Reed, kicking it back to you.
Yeah, so a few other categories of information that folks will be required to disclose: information regarding foreign competition filings, information related to licensing agreements between the parties or other agreements between the parties. I mentioned previously prior acquisitions. The acquired entity is going to be required to submit information about prior acquisitions in some areas, some foreign government subsidies, certain defense and intelligence contracts. I mean, the list is even much broader than what we've covered today, but these are some of the highlighted areas. And then a couple other changes outside of the additional information. The FTC has said that they will reinstitute early termination. They have said that now they'll be receiving the information that they need in order to make a determination, an initial determination on the competitive nature of the transaction. And so that will allow them, in some instances, to issue early termination and provide clearance prior to the 30-day waiting period being expired. Also, they have put a little bit more of a framework around when it's okay to file an HSR on an LOI. There's still some ambiguity in the instructions in the final rule, but there's a little bit more structure around what the LOI may need to include. And then lastly, the FTC has created an online portal whereby any individual or business can go to this portal and submit a comment to the FTC about a transaction that may be under review. And the FTC has hailed this as a way for individuals and businesses to directly provide comments without having to hire a lawyer and walk into the FTC, although in some instances, folks will still probably want to hire a lawyer and do that. So I'll turn back to Holden for some practical implications.
Okay, so in the last 60 seconds here, we're going to give you 4 simple steps that you can take to prepare for this new regime. Number 1, account for greater time needed to prepare HSR filings. It used to be that we could get a call from our deal team at McGuire Woods, and they would say, we have an HSR. Can you file it in 5 days, 10 days, whatever it is? We would say, absolutely, no problem at all. We would do it. I think that is unfortunately a thing of the past. We're going to need to start thinking about that HSR timeline far in advance and start managing expectations of our internal business teams at our clients, et cetera, for how long that HSR preparation is going to take. Number 2, you could start thinking now about how you want to organize information to make it more easily accessible if you do have an HSR. If you know you have a likely reportable deal coming up in 2025, maybe start storing and organizing information in a way, identify this strategic deal team lead individual, put your officers and directors on notice that you will be coming to them for information about the transaction, et cetera, to get a jump start on that process. Number 2, think about this broadening lens that the FTC now has with respect to deals. How good are your document creation, hygiene protocols? Do your business teams understand that they need to be precise and accurate in their description of competition, competitors, market share, et cetera, in order to avoid creating problematic, misleading documents that may be reviewed in the context of a HSR filing? And second, think now about who your internal lead is going to be when you do get a call that you need to file an HSR. Do you have a paralegal who could benefit from some advanced education about what's coming down the pike? Do you have, an analyst or someone else who you would like to deputize as being the person who's going to be familiar with how your company is going to handle these requests? we think it's a good idea to have those meetings now so that people are not shocked and surprised when the new rules do take effect. Reed?
Yeah, last slide is on the potential impact of future investigations. I think the takeaway is the substantive impact, remains to be seen. The FTC is going to have a lot more information up front. How that impacts the way that they investigate down the line is a little bit less clear, and we'll find that out in the coming weeks and months. And with that, thank you all very much for joining us today. We appreciate your time, and we hope that you'll join us again for these webinars in the future. Thank you.